Okay. Hi guys, welcome you all to the September Roundtable for Nickel and Dimed, initiated by Center for New Economic Studies. So we are the Legal Studies cluster, and for this month's roundtable, the topic we are going to deal with is the legal dimensions of combating online harassment and cyberbullying in India. We will be dealing with a complex and a varied number of questions in this now. The first question will be dealt with by Diksha Mittal. So yeah, off to you, Diksha. Please take it forward.
Hi everyone. So I would be taking the first question. So the legal landscape in India addresses online harassment and cyberbullying through a combination of legislation and judicial interpretation. And these laws aim to protect individuals from various forms of digital abuse. But we will delve into legal definitions and scope of online harassment and cyberbullying in Indian law. So, firstly, we will deal with how Indian law specifically define or like tell about cyberbullying and its related offences. So, firstly, we will be looking at the ITA Act, which is Information Technology Act of 2000. So, the ITA is the primary legislation which governs the cyber crime in India. While it does explicitly define cyberbullying, it involves various forms of online harassment. So, it includes some of the relevant sections which we will discuss. One of the section is section 66A, which has been repealed. So previously, this section dealt with sending offensive message online, but it was struck down by the Supreme Court in the year 2015 for being vague and unconstitutional. Another section is 67. So we still have this section, and this section addresses the publication or transmission of obscene material in electronic form. And the another section of ITA Act is Section 67A. So this section is pertaining to the publication or transmission of sexually explicit content involving minors. And the another section is Section 66C. So this section addresses identity theft and unauthorized use of electronic identity. And the last section of the ITA Act is Section 66D. So this section also deals with cheating by the personation using a computer resource relevant to impersonation based harassment. Next, Indian law, which we will be discussing, would be IPC, which is Indian Penal Code. So, IPC also contains provisions that are applicable to cyberbullying. So, one of the provision is Section 499. So, this section defines defamation, which includes publishing a statement that harms a public reputation. And the another section is section 500. So this section prescribes a penalty for the defamation which we defined in the section 499. And the another section which is for the cyberbullying is section 354D. So this section addresses stalking which can occur online and is considered a form of cyberbullying. And the last section of the IPC is section 507. So this section covers criminal intimidation by anonymous communication relevant when threats are made online. So when the threats are made in the online form, this section covers those type of cyberbullying. Now coming to the POXO Act, so it is Protection of Children from Sexual Offences Act of 2012. So this law primarily deals with child sexual abuse, but can be relevant when cyberbullying involves minors and explicit content. The another law could be news media laws. So in the recent years, India has proposed new media laws and guidelines for social media platforms to curb the spread of fake news, hate speech, or harassment. While these are not specific to cyberbullying, they can indirectly address such issues. So these were the Indian laws which define or tells about cyberbullying or its related offenses. Now we would be discussing about the legal distinction between different forms of online harassments. So Indian law do recognize distinction between different forms of online harassment. One of them is cyber stalking. So, cyber stalking typically involves a pattern of harassing or threatening behavior which is happening online, in an online form, in a digital form. So, Section 354D of the IPC explicitly addresses stalking and can be applied to cyber stalking cases. We just discussed Section 354D. So, this section defines cyber stalking. The another form of online harassment is defamation. So defamation comes under section 499 of IPC, which apply to online statements that can harm any person reputation. And defamation may also involve the false statement made with the intent of to harm someone character or reputation, which is with the intent of harming that person reputation. So, and the another legal distinction of form of online harassment is hate speech, which we see in the present time, which is very common in the present time. So, while for the hate speech, there is no specific law which defines the hate speech, but IT and IPC provisions on hate speech can be used to address online hate speech that incites violence or promotes kind of difficulty or uh, problem regarding the cyberbullying. And the another form is sexting and child sexual exploitation. So the IT and POXO Act specially addresses the distribution of sexually explicit content involving minors, including cases where such content is used for harassment. So, uh, so we have till now we have discussed Indian laws which specifically define or categorize cyberbullying, and we have also made distinction between different forms of online harassment. So, in conclusion, Indian law addresses online harassment and cyberbullying through various statutes, although the term cyberbullying is not explicitly defined anywhere. So, different legal provisions apply to various forms of online harassment, such as cyber stalking, defamation, hate speech, with the IT Act or IPC being the primary legislation to combat them. Over to the next person.
Thank you, Diksha. The next person can go forward now.
Hello. So I will be talking about different provisions and different case laws pertinent to cybercrime as well, starting with some of the IPC sections, other than the ones that Diksha mentioned. So firstly, Section 292 of IPC. The purpose of the section was to address the sale of obscene materials. However, in this digital age, it has evolved to deal with various cybercrimes as well. A manner in which obscene material or sexually explicit acts or exploits of children are published or transmitted electronically is also governed by this provision. The penalty for such acts is imprisonment and fines up to 2 years and rupees 2,000 respectively. The punishment for any of the above crimes may be up to 5 years of imprisonment and a fine of up to 5,000 for repeat, that is second time offenders. Secondly, Section 354C of IPC. In this provision, cybercrime is defined as taking or publishing pictures of private parts or actions of a woman without her consent. In this section, voyeurism is discussed exclusively since it includes watching a woman's sexual actions as a crime. In the absence of the essential elements of this section, Section 292 of the IPC and Section 66E of ID Act are broad enough to include offences of an equivalent nature. Depending on the offense, first-time offenders can face up to 3 years in prison, and second-time offenders can serve up to 7 years in prison. Now, Section 354D, which includes stalking, including physical and cyber stalking, is described and punished in this section. The tracking of a woman through electronic means, the internet or email, or the attempt to contact her despite her disinterest amounts to cyber stalking. This offense is punished by imprisonment of up to 3 years for the first offense and up to 5 years for the second offense, along with a fine in both cases. A victim in the case Kalandi Charan Lenka versus State of Odisha has received a series of obscene messages from an unknown number that had damaged her reputation. The accused had also sent mails to the victim and created a fake account on Facebook containing morphed images of her. The High Court in this case therefore found the accused prima facie guilty of cyberstalking on various charges under the ID Act in Section 354D of IPC. Section 379 of IPC talks about punishment involved for theft, which can be up to 3 years in addition to the fine. The IPC section comes into play in part because many cybercrimes involve hijacked electronic devices, stolen data, or stolen computers. Um, Next, section 420 of IPC talks about cheating and dishonesty, including delivery of property. 7-year imprisonment in addition to a fine is imposed under this section on cyber criminals doing crimes like creating fake websites and cyber frauds. In this section, crimes related to password theft for fraud or the creation of fraudulent websites are also involved. Then, in section 365 of IPC deals with the punishment for forgery. Under this section, offences such as spoofing of emails and the preparation of false documents in cyberspace are dealt with and punished with imprisonment ranging up to 2 years or both. In Anil Kumar Srivastava versus Idle Directioner, the petitioner had forged the signature of the AD and had then filed a case that made false allegations against the same individual. Now, due to the fact that the petitioner had also attempted to pass it off as a genuine document, the court held that the petitioner was liable under section 465 and 471 of the IPC. Furthermore, there are many more sections of the IT Act and the Indian Penal Code which pertain to cyber crimes, in addition to the laws that I stated and as well as the law stated earlier as well. And even though there are laws against cybercrime in place, the rate of cybercrime is still rising drastically. It had been reported that the cybercrime in India increased by 11.8% in the year 2020, which accounted for reporting around only 50,000 cases. Moreover, cybercrime is one of the toughest crimes for the police to solve due to many challenges they face, including underreporting, the jurisdiction of the crime, public unawareness, and the increasing costs of investigation due to technology. Certain offences may end up being bailable under the IPC, but not under the ID Act and vice versa, or may be compoundable under the IPC, but not under the ID Act and vice versa due to the overlap between the provisions of the IPC and the ID Act. For example, if the conduct involves hacking or data theft, offences under sections 43 and 66 of the ID Act are bailable and compoundable, whereas offences under section 378 of the IPC are not bailable, and offences under section 425 of the IPC are not compoundable. Additionally, if the offence was the result of stolen property, the offence under Section 66B of the ID Act was bailable, while the offence under Section 411 of the IPC was not. Um, Similarly, in the respect of the offense of identity theft and cheating by personation, the offences are compoundable and bailable under Section 66C and 66D of the ID Act, whereas the offences under Section 463, 465, 468 of the IPC are not compoundable, and the offences under Section 468 and 420 of the IPC are not bailable. Lastly, I would like to cite another case by the Bombay High Court, Gagan Harsh Sharma versus the state of Maharashtra, wherein the High Court addressed the issue of non-bailable and non-compoundable offences under Section 408 and 420 of the IPC in conflict with those under Section 43, 66, 60 of the ID Act, that is bailable and compoundable. Lastly, I would like to discuss Companies Act 2013. Now, a majority of the corporate stakeholders consider the Companies Act 2013 to be the most pertinent legal obligation to properly manage daily operations. This act enshrines in law all the techno-legal requirements that need to be met. Implementing the law is a challenge to the companies that are not compliant. As part of the Companies Act 2013, the SFIO, which is Serious Fraud Investigation Office, is entrusted with powers to investigate and prosecute serious frauds committed by Indian companies and their directors. As a result of the company, I'm sorry. As a result of the company's inspection, investment, and inquiry rules 2014 notification, the SFIOs have become even more proactive and serious in regard to this. By ensuring proper coverage of all regulatory compliances, the legislature ensured that every aspect of cyber forensics, e-discovery, and cybersecurity diligence is adequately covered. Moreover, the company's management and administration rules 2014 prescribe a strict set of guidelines that confirm the cybersecurity obligations and responsibilities of corporate directors and senior management. We can move on to the next person.
Yeah. Thank you so much, Ishita. Now I will be taking this up forward. I will be dealing with three things. First of all, as you already mentioned, and Diksha also mentioned, the Information Technology Act. I will be taking that forward. I will be discussing the role of Information Technology Act in detail. Then I will also talk in detail about the challenges in law enforcement. One of the challenge that Ishita also already mentioned is the overlap between laws, but I think there are many other challenges that come forth with any kind of crime that happens online. And at last, I will be talking about how do we balance privacy concerns and the privacy concerns and the privacy of anonymous perpetrators in this regard, because we whatever is happening, the kind of cyberbullying, cyber stalking, cybercrime that happens, it happens from behind a screen. Yeah. So the role of Information Technology Act, the Information Technology Act, which came into force in 2000, the year 2000, and its subsequent amendments play a significant role in regulating online harassment in India. The Act addresses various aspects of cybercrime, including cyberbullying, stalking, and online abuse, and it provides legal provisions to combat these offenses, which are spread across Section 66 and 67 of the Act. I will not be dealing with what the specific subsection of each section says, but broadly, these sections criminalize the sending of offensive messages online. They deal with the publication or transmission of obscene material in electronic form, publication or transmission of sexually explicit content involving minors, identity theft, and they also punish the unauthorized use of someone's else electronic identity. They address cheating by personation using a computer resource, which is relevant when the perpetrator impersonates someone else online to commit offenses. Now, like these are the broader sections. This is everything that the IT Act essentially deals with. But the IT Act has actually gone through a lot of amendments which do come into the right play here. We had an amendment in 2008. This amendment included offenses related to data privacy under the IT Act in terms of hacking and introducing stricter penalties for cybercrime. In 2013, we had another amendment which addressed concerns related to cybercrime, including revenge pornography, and introduced provisions for the removal of offensive content. In the year 2019, we focused on data privacy of India. This was done after this was done after to cybercrime. There is a very thin line which you have to maintain between the data privacy of the victims as well as the offenders. We also have the cybercrime reporting portal, which was established by the government for facilitating cybercrime reporting mechanism, and social media guidelines, which were very recently launched a few years ago for social speech harassment. These are the broader. This is the broader idea of what is covered in the Information Technology Act. Now I will move forward to deal with the challenges in law enforcement that occur in terms of prosecuting online harassment cases. First one being anonymity. Perpetrators often hide behind an online anonymity, making it difficult to trace their real identities. And nowadays we have so many uh, existing paywalls or some kind of walls that really make the whole idea of anonymity very easy. People use VPN nowadays, so it becomes very difficult and challenging to address this. We also have jurisdictional issues. The internet transcends geographical boundaries, as we all know, leading to jurisdictional complexities when pursuing offenders operating from different regions or countries. Per se, every country has different standards for this. For example, if a crime like this is committed in the European Union, I'm pretty sure the kind of punishment it will attract, and the kind of seriousness it is going to attract, and the kind of laws that are going to be applicable are going to be much stricter than that in India. So the jurisdictional issue really comes in play here. Then we have encryption. Use of end-to-end encryption can hinder efforts to intercept and decipher communication related to harassment. This makes sense. As you all know, all our WhatsApp messages are end-to-end encrypted, and this really comes into the play here because these make sure that the conversation is not leaving the two devices it is being exchanged into, which really presents its own problems here. This also actually comes in tie with the technological advancements. The more the technological advancements, the more it might actually be easy to kind of trace cybercrime, but it actually might actually like become difficult. Then you also have lack of awareness. Many people are not still aware about the laws, the facilities they do have. I also wanted to deal with a few things that can actually help address the problems here. First is digital footprint analysis. Cyber forensics experts can analyze digital footprints left by perpetrators, including IP addresses, timestamps, and online behavior patterns. It can really come into play here. And one way the technology can also help us here is AI. I think the use of AI in online harassment can actually give us very good results because we can train the AI, like we can train the machine to identify and track cyberbullies, a particular kind of behavior, particular kind of words that if used across the internet, they can be tracked by AI, and it can actually help streamline the process a lot. Now, lastly, I wanted to deal with privacy concerns and anonymous, which is the last question I'm dealing with. Anonymity, anonymous perpetrators, and privacy concerns. So I think here one of the prime threads that we need to connect is national security and online harassment. I think we need to have different rules and different guidelines the cyber security concerns, cyberbullying, online harassment concerns that actually also come into like bring into the perspective the national security. In cases involving national security concerns, authorities may have more leeway to request user information, often subject to strict oversight and legal procedures. And where we have lack of evidence of serious cybercrime or online harassment that pose a threat to public safety, law enforcement may seek court authorization to unmask anonymous perpetrators. I think permission can actually be used here, whether it is normal criminal investigation or something that concerns national security. Now, we also need to talk about some balancing of efforts with deal with individual privacy protection. First of all, will be proportionality. The actions taken to unmask anonymous perpetrators should be proportionate to the severity of the offense and potential harm caused. So we do want to highlight the fact that the kind of cybercrime that any perpetrator is committing should be in line with their data protection as well. The more like it is very much similar to other criminal offenses. Obviously, a person who steals something is going to go through much less seriousness or maybe like public sentiment as opposed to someone who did a like who's a sexual offender or committed a murder per se. Now we have data minimization. Law enforcement should only seek and detain the minimum amount of user data necessary in investigations, which is also important. Such kind of data should be handled with a lot of transparency. Public awareness of the circumstances under which privacy can be compromised and the legal safeguards in place is crucial for maintaining the process. And I think at this juncture, we can also refer to various international standards. I think when it comes to data privacy, and online harassment, online cyberbullying, we can take a cue from the European Union. Their data privacy laws and their online harassment laws are great. They are completely at par and were referred by many international, many countries. And I think India can also make use of that. With that, we will move forward with the sixth question. And uh, yeah, I will pass it on to the next person. We will be talking about the legal remedies available for victims. I think Arushi Suvarna had to do the next question, but she's facing some connectivity issues. So if Arushi Singh could go before her, and then
Uh,
the other person can continue.
sure, I could, but my Wi-Fi is a bit weak, so I would like to keep my camera off while I speak. Is that fine? Okay, so I'm supposed to talk about the civil and criminal remedies and their interplay during in the case of online harassment or cyberbullying. So first, I would like to talk about what is our criminal and civil remedies and how are they different. So criminal remedies basically are more offensive and they are focused on punishing the criminal or the wrongdoers and to protect the society as per. So they are meanwhile the civil remedies they are focused on protecting the victim and like, getting them the compensation and all. So there are a lot of differences between the criminal and civil case remedies. However, they work together sometimes, but there is a I am sorry. So I'm sorry. Yeah. So in criminal cases, the burden of proof is on beyond reasonable doubt, and it is a much more higher as compared to the civil remedies where the plaintiff is supposed to prove. And so a lot of the times what happens is they go parallelly in and but yes there's no double jeopardy in them. Double jeopardy is basically up the principle that prevents a person from trying twice for the same offense. So even though the offense is same, but they are even though they are talking about the same conduct, they are considered to be separate proceedings. Therefore, the double jeopardy principle does not apply. Now, when it comes to online harassment, uh, so I would talk about the civil remedies available to the victims, and then I would talk about the criminal remedies in the cases of online harassment. So the civil remedies are so they can get injunctions against the harasser, or they can get compensation, as well as they can also get the restraining orders against whosoever is harassing them. Whereas on the criminal remedies, they can get file a prosecution case or they can get criminal charges as well as deterrence. Now, the interplay between the two is seen in case of accountability, that there's a sense of accountability and exposure for victims in both civil as well as the criminal one, as well as the both of them offer a more comprehensive approach to combat online harassment if you go if they are interplayed, and even the timings like it saves a lot of time to like if you file both of them together. And even the evidence, like for example, if there is a case and you are presenting, it's a civil case and you are presenting the evidence, the same evidence could also be used in criminal proceeding as well. However, there are a few challenges to them as well. Number one being privacy. So they involve the criminal cases sometimes involve a lot of public disclosure, which is not a very good alternative for the people with who respect their privacy and sometimes the information is way too sensitive for it to be made public, as well as the variability of jurisdiction is also there. So the availability and effectiveness may vary by jurisdiction depending on the local laws or the procedure you opt for. And yeah, so I would now like to talk about what are the advantages and the limitations of pursuing both simultaneously. So as I just said, the the advantage being the evidence and even the protection, and because in civil cases victims can obtain restraining orders and injunctions against the person who's harassing them, which can protect them if they are filing a criminal case against the harasser, because in a lot of cases victims are made to not appear in front of the court, or they are harassed if they file a criminal proceeding against someone. And so in there's also the advantage of, again, uh, the justice, like the criminal civil cases provide victims with a means to seek compensation for the damage, be it emotional distress or even medical expense, because a lot of people they try to commit suicide because the bullying has reached a certain point, and simultaneously, while pursuing the criminal charges, they can help the victim find closure and a sense of justice. However, the limitations, again, as I said, privacy, and also it becomes a bit complex, like the legal procedure pursue both of these remedies simultaneously. It becomes a bit complex, as well as pursuing both civil and criminal cases can be a resource intensive for victims, like legal fees, court costs, and the time and the even the emotional energy required for both to experience can be burdensome. And the outcome of criminal and civil cases can vary huge in a very huge way. And in criminal cases, the wrongdoer may be acquitted due to the high standard of proof required, whereas in a civil case, the result may be against the victim, like they do not get compensated as much as they should. So that's why simultaneously pursuing both civil and criminal cases in situations involving such as cyberbullying can hold the wrongdoer accountable, provide justice, and offer possibility of compensation. However, it is essential to consider the limitations, including the resource intensive nature and privacy concerns. Until ultimately, the decision to pursue both should be made carefully, I would say, taking into account the specific circumstances, the need, and also the wishes of the first victim. And the interplay between these two processes can provide a more comprehensive avenue for justice, but should be undertaken with a clear understanding of its advantage. Now, I would be talking about how the final thing, how can the legal system streamline these processes to provide comprehensive protection to the victim. So, one way to do that is like implementing integrated case management system for coordination and information sharing between civil evidence sharing, basically between the criminal and civil cases, to facilitate the proceedings in a more efficient manner, as well as there can be victim advocacy programs, which like it would provide victims with legal support and guidance throughout the legal process, and can also help the victims understand their rights and navigate the court procedures, as well as like ADR. ADR can use methods like mediation and arbitration for the civil cases involving with victim protection, and it is a much more faster and less adversarial solution, while still ensuring that victims are compensated and protected. So yeah, that's it.
Am I audible?
Yeah, you're audible.
Okay, good evening. I will be discussing the legal remedies available to victims of online harassment, and I'll be discussing how the legal system can provide like a faster and more effective relief to victims. So, the emergence of internet and social media platforms, while has greatly contributed to improve technology, it has also given rise to online harassment. And people are more frequently subjected to online harassment, as discussed before, in different forms, such as cyberbullying, cyberstalking, hate speech disparages, and revenge porn. And this has obviously been like an increasing problem. While there are many ways to report these crimes, firstly, you can report to the platform in itself. So the first step would be to report the abuse on the platform that you're using it, especially online platforms like Instagram and like Twitter, and all of these online platforms have a way to report these crimes instantaneously. And then the second way is to file a complaint. So if the harassment is severe and like threatening, you can file a complaint with the cybercrime cells. There's an online portal, NCCR, which is the National Cybercrime Reporting Portal, which is a government initiative that caters to complaints pertaining to online child pornography, child sexual abuse material, or sexually explicit content as well. It also covers cyber crimes like social media crimes, online financial frauds, hacking, etc. This can be filed both online and offline. And it's very important to know that the victim does not need to file this complaint with the cybercrime cell that he or she resides in, because this falls under the purview of global jurisdiction. And the crimes can be anonymous complaints as well. The most reliable way to file or report this crime would be in writing, because a lot of people cannot afford internet expenses or lack of relevant information, and so on and so forth. The cybercrime cell's head must receive like a written complaint that includes like information about name, contact information, postal address, and most of these basic information. Next would be you could even file a complaint with the police station under Section 154 of the CRPC. If the offense is a punishable offense under the IPC, then the police has or is required to file an FIR. And if they refuse to do so, you can always take it up with, you can go file a complaint with the judicial magistrate. Then we have the National Commission for Women that also has authority to set up like an inquiry committee, conduct spot inquiries, interrogate, and like collect evidence, etc. A complaint can be made to them online or physically by submitting a written complaint in their office. If the harassment takes place in your workplace, then there's the POSH policies in place. So in case the perpetrator happens to be from your workplace, and the POSH committee can conduct an internal inquiry and like take the necessary disciplinary action. As discussed before, we have multiple legal remedies and legal recourses that can be sought under the Information Technology Act, the Indian Penal Code, POCSO, and like the Criminal Amendment Act. I don't think I have to go through the sections again. Now there are multiple ways like the legal system can take to provide like faster and more effective relief to victims of online harassment, such as they could establish like a user-friendly and accessible reporting mechanism that could include dedicated hotlines, online reporting platforms, and in-person reporting centers. Then they can implement expedited investigation procedures specifically for online harassment cases, which could involve prioritizing cases to ensure that this case has been like promptly assigned to an investigator so they can start the investigation immediately. They can collaborate with technology experts and digital forensics specialists who can enhance investigative techniques by, say, collecting and preserving digital evidence, analyzing online communication data, and identifying anonymous perpetrators. Then they can start enhancing the training and resources available to law enforcement to help navigate the complexities of this online harassment by including training programs like that can focus on digital forensics, cybercrime investigation techniques, etc., because this is fairly different and new. The courts can implement a fast track procedure specifically designed for online harassment cases. Then the basic ones could be the fact that they need to start raising awareness about online harassment and its consequences in public education campaigns and so on. There also needs to be a stronger partnership and coordination between the legal system and online platforms so as to enhance the effectiveness of such reliefs. Thank you.
Thank you so much, Arushi. The last question will be dealt with by Akshat. So over to you, Akshat. You can deal with it and then conclude this discussion.
Yeah, just a second, please. My camera doesn't seem to be turning on. If you could just give me a moment. Uh, right, am I audible? Yeah. So, as had been discussed, I will be dealing with some of the jurisdictional problems in online harassment cases and how the Indian law can handle such perpetrators when they are outside of our country. Now, the jurisdictional questions and applications still remain a legal gray area, which is why we'll be looking at more conceptual questions rather than their specific application. Now, while legal remedies do on paper, as had been pointed out by the people before me, they do envision extraterritorial application, the monumental coordination, the international effort involved, and since severity of the crime would not warrant typically extradition, it does pose a rather complex jurisdictional question. Now, in addressing jurisdiction, now the territorial jurisdiction, whether there will be a conflict of laws between the countries in question, since it is a matter of personal law, and there is a lack of uniform legislation across countries worldwide, which is something which ought to be addressed subsequently. In the absence of the same, it does pose a bit of a problem as to prosecuting individuals outside the countries. Now, data localization and privacy laws across countries, these also affect the ability to gather evidence, as it may be stored in different jurisdictions. Now, as we discussed, the IT Act governs many aspects of cyberbullying, and it allows, on paper, under Section 75, the Indian authorities to pursue cases where a perpetrator is outside the country, as long as the victim or there is a proximate nexus to the Indian territory in question. Now, in applying the same, India can also seek assistance from other countries through mutual legal aid assistance treaties. Now, MLATs can be time consuming and might not always be effective, but it would be a significant measure. And this significant measure can be temporary in a larger long term framework as to bilateral or multilateral agreements specifically addressing cybercrime resolution mechanisms between countries in order to simplify the investigative process. Now, the Interpol and United Nations, while they do have certain guidelines, now these guidelines are more of as an advisory ground. Now, if we are to provide a standardized framework across nations in handling cross-border cyberbullying, this can facilitate cooperation between nations. Now, the data sharing and reporting mechanisms between such countries, in addition to capacity building and law enforcement capabilities, would be extremely relevant because, again, the question of addressing something which is, of course, the Indian Information Technology Act and claiming extraterritorial jurisdiction, the question of extradition comes in. Now, extradition in cyberbullying cases is not unprecedented. In fact, most recently in the Canadian case, uh, the popular Amanda Todd cyberbullying case, and Dutchman had lost his appeal for extradition for his alleged role in cyberbullying of a 15-year-old Canadian girl who took her own life as a result. Now, while it is tragic that it needs to materialize into such a significant level for it to be prosecuted effectively, for it to involve public outcry, now this is very often the necessary or the basic ground in order for it to catch the public eye and effectively materialize into an extradition. Now, if we are to simplify the trials between several nations based on the magnitude of the cybercrime not being the sole determining factor, because we cannot take a completely victim or damage oriented approach over here. We cannot wait till there is something of this magnitude in order to take action. So, in addition to awareness campaigns, as had been dealt with earlier, we have sufficient capacity building and harmonization between jurisdictions. It would be the most effective measure in resolving cross border cyberbullying. Now, as I pointed out, while Indian law, to conclude, does have provisions to address such cases, the extraterritorial jurisdiction hasn't really materialized in practice. There are complex international jurisdictional challenges. However, if we do enhance international cooperation, both in terms of obligations by agreements between nations, in addition to a certain level of cooperation and a mutual framework, standardized procedures, data sharing, and capacity building efforts spanning countries and jurisdictions can effectively handle the significant issue that's plaguing the world, that is cyberbullying across borders as well. So that would be it then. Thank you.
Thank you so much, Akshat. Thank you so much, everyone. Actually, it was a really fruitful discussion, and I will be stopping the recording now. And yeah, I'll see you guys next time. I have received the submissions from most of you. I will be sending them for the second round of edits now, and they will soon return. And then you can see them published, and I'll share the link with you. Okay, thank you. Good night.
Thank you.